Do you have, it's page 62 of volume 1.
Yes. Okay.
You see paragraph 1 of the order, it mentions the sections. And I'm not certain, and I speak only for myself, that it identifies the constitutional infringement. It says it's declared invalid and inconsistent, and then usually it should follow after that, to the extent that. And I'm not sure that what follows identifies the constitutional infringement that we're dealing with. Because it then says, to the extent that these provisions do not criminalize sexual violence where the perpetrator wrongly and unreasonably believed that the complainant was consenting. Do you understand that?
Yes, and it should have said to the extent that they infringe on the rights to equality, etc., etc.
And I'm struggling to make that link.
Yes.
That even if we do say that, I'm struggling to make the link. How does the unreasonable belief that the victim was consenting infringe those rights that are referred to in sections 3, 4, 5, 6, 7, 8, 9, and 11?
I suppose the simplest way to explain it is this, that the unreasonable belief permits the offense. So the unreasonable belief permits a rape to happen. And that's the link. That if all we cared about was was the subjective intention of the accused, did he think that she consented or not, the effect would be to ignore all of her rights. So the effect would be, it's really just what the man thinks. Does she consent? So for example, I know marital rape is no longer a crime, but we are married, as an example, and therefore she must consent to sex. As a very simple equation. That ignores all of the rights that are protected then when there's an unreasonable belief.
If I understand your answer, the problem then is, how do we interpret and find consent? And how do we find where there has been no consent?
So yes, and when we try and answer that by saying, how does the perpetrator determine consent, right? The perpetrator determines consent either by objectively verifiable circumstances or by taking reasonable steps to determine consent specifically.
Yes.
But without those, it's really we're back to the subjective intention.
And the legislature says it's an offense where there's no consent. Isn't the problem really how we interpret and apply consent? And when I say we, I refer to the judiciary.
Yes. So if I understand...
Instead of with the legislation. So the legislation says if there's no consent and the act occurs, it constitutes rape. Isn't it the function of judicial officers then to interrogate the question of consent and to interrogate it broadly to cover the possibility of where there can be no consent through a freezing of the victim?
What's missing in that analysis, Justice Theron, I would submit, is the fact that the legislature has used the word intent in the provision. So the intention requirement is what takes us to the subjective intention of that a court can't get around. So that even if a court was looking at consent, so for example, in Ms. Holstrager's case, the magistrate said very clearly, it was clear she did not consent to sex. She says that specifically. It was clear she did not consent to sex from all of the evidence that was run, including medical evidence. But, she said, I still can't convict under this act because intention requires a subjective analysis, and subjectively, the state was not able to prove beyond reasonable doubt that he knew that she wasn't consenting. So it's not simply, consent is one of those factors, but it is not the whole analysis. Intention is the core analysis there.
But I thought we were here in court about consent today.
No, we're in court today about intention and consent. It's the combination of those two factors that you will find in each one of the impugned provisions. And it's those combination of factors we say that triggers the problem.
Doesn't the definition of rape also refer to intent?
Yes, absolutely. Every one of these crimes has both intent and consent.
So if we tinker with intent, to what extent are we tinkering with it? What is the applicant asking the court to do in relation to intent?
I suppose what we're doing is effectively asking this court to impose an objective measure of intent, which is what Justice Colopin was, I think, asking me earlier. So the effect of our relief would be to say that where the accused, and only in the situation where the accused wishes to raise a defense of consent, he would have had to take reasonable steps to determine that consent. A court would then have to evaluate whether those steps were in fact reasonable, whether he took steps at all, and whether they were reasonable. The state would have to prove where consent was raised, and it's important that we understand that this only happens in the world where an accused pleads a defense of consent. In that situation, the state then has to prove that objectively, all of those objective facts show that subjectively he knew she didn't consent. So I suppose the logical answer is it's taking it away from a subjective intention and closer to an objective analysis, which then gets us closer to negligence.
Okay. Your answer leads me to my next question. When we talk about negligence, are the embrace applicants, in terms of the relief that they seek, if the relief is granted, we would then be criminalizing negligent rape?
Yeah, and we said there is nothing wrong with that. We criminalize negligent conduct. In many, we criminalize negligent murder.
Yes, but this is now, I think my question is to me a little bit more difficult because you readily conceded the first one. Does this court have the power to create new offenses?
Well, what we're asking this
We
court...
then, and I'm basing this on the answer that you gave, we'll be creating the offense of negligent rape.
Justice Theron,
Isn't that an overly intrusive remedy which would usurp the power of the legislature?
Justice Theron, my immediate question is, what is the alternative for this court, first of all? I don't submit that this court has the power necessarily to create new offences. But the alternative is for this court to find...
Sorry to interrupt you.
Not at all.
If, that's the next step. If this court does not have the power to create new offences, then it cannot create a new offence of negligent rape. And we need to answer that question first without looking at the facts of this matter as to how it would affect the victims of rape. We need to answer the question of the power of the court independently first. Does this court generally have the power to create a new offence?
Let me turn this around a little bit. What we bring to this court is what we see as a patent unconstitutionality. And it is the job of this court to declare all conduct and acts unconstitutional as such. If this court is of the view that its concern is with the remedy that we propose, not the unconstitutionality, but the remedy, then we must talk about that, perhaps. Because whatever happens, we submit that this court must declare the act unconstitutional. And if this court decides, well, we'll leave it to Parliament to fix, so be it. We've submitted that it is permissible for an interim reading in until Parliament does whatever it is appropriate to do, whether that is to create another offence, whether that is to adopt a coercive standard, whatever that may be. But it cannot be that this court does not declare conduct or an act unconstitutional where it finds that it is so. My learned junior is just pointing to me to something, if you bear with me. It's always good to have very clever juniors, and I have three of them. Justice Theron, my junior points me to the Masia case. And in Masia, this court created a new offense, that of anal rape. So if one looks at paragraph, in the order of Masia, that's paragraph 74, the order is to make a declaration of of invalidity and confirm the High Court judgment. And then it says, the order of the regional court referring the criminal proceedings to the High Court for purposes of sentence in terms of a particular provision is set aside. The common law definition of rape is extended to include acts of non-consensual penetration of a penis into the anus of a female. So it is an extension of the existing law. Now, I know that your answer is going to be that's not the creation of a new offense.
It's not a creation of a new offense. It was still rape, but it just broadened the categories.
Well, sorry. Is that so
Becomes
different,
clearer.
my lady?
If we look at murder,
Yes.
murder with intent, murder.
Yeah.
Negligent murder, culpable homicide. Two separate offenses.
But you would submit that it's not that different. It's not necessarily two different offenses. That it is that the relief that we see could actually be seen as an extension of the offense. So, if you just bear with me as my mind just works this out, I think that if the offense is rape, for example, it would still remain rape in effect. It's not creating a new offense called negligent rape. It's an extension of how we understand rape. And that this court would be allowed to do in line with Masia.
In your submission, Ms. Rajab-Budlender, you identify the problem in rape cases as being the reliance on the subjective mens rea standard. And if I understand your submissions, the definition would remain the same, namely the unlawful intentional sexual penetration of a complainant without their consent. The remedy that the embrace applicants seek, they don't seek to change the definition, which would still require intention and dolus. Now, how can the relief that's being sought by the applicants be reconciled with the definitional elements for the charge of rape?
Because, Justice Theron, we say that we locate the fix in the defense, that this only applies, it doesn't apply in every rape. It's not going to apply in every rape. It's only going to apply in rape where the accused raises a defense of consent. And the way in which the statute is currently structured is to place defenses separately to the offense in Section 56. So that is the way in which we've crafted the relief, to leave the offense intact, but where there's a particular circumstance of the raising of defense of consent, that it's dealt with in the way that we suggest.
Is there not a way to deal with it without tinkering with the legislation? And it brings me back to one of the earlier questions I asked about judicial application and interpretation as to what is the meaning of consent. And the problems that we see may go back historically and influence how judicial officers interpret and apply the meaning of consent. So my question really is, should judicial officers not be interrogating whether there is meaningful consent?
Yes.
And that would cover the test that the embrace applicants seek to advance. In other words, and I know this is a long question, I don't really like asking long questions, would a reading in of the word meaningful before consent offer a suitable remedy? you need more time, you can address it.
I do want to consider that because I'm worried that that itself may open a debate of what's meaningful consent, what's non-meaningful consent. I think if we take a step back and look at what brought us here as a way to working out what remedy we seek, what brought us here is a magistrate saying to us that the law as it stands, as she understands it and as she implements it, requires only an analysis of the subjective intention of the accused to have been proved, and that the state was not able to prove that because there were no objective indications of a lack of consent. What we see in the courts is an inability, is a lack of certainty, is an inconsistency in how these provisions are being dealt with. What the embrace applicants seek is, why we come to this court, is to assist us with that problem. We persist in the fact that we think that the Act as it's framed is unconstitutional. And you can see that even from the foreign jurisprudence where the countries that we referred to, the UK, the US, Canada, and New Zealand, have all moved away from a formulation of a statute that looks like ours to incorporate this reasonable steps requirement. There's a reason that they've done that, because they themselves believe that this, as it's presently formulated, is unconstitutional. But if this court is not convinced of that, then we would ask this court to attempt to fix the problem we bring to you, which is to give guidance to our magistrates, our high court judges, about what this provision means. If it doesn't mean, if this court finds that it doesn't mean subjective intent means not looking at objectively verifiable manner of determining consent, this court must say so. What is absolutely clear, just in my time of working on this case, is that this lack of certainty is resulting in daily injustices to women in our magistrates' court, in prosecutions for rape not happening at all, let alone not being successful. So there is very clearly a problem here. And we come to this court to solve that problem. How we solve that problem is less our concern. We've suggested a manner in which we think it should be solved that's constitutionally compliant and that's minimally intrusive to the statute. If this court disagrees with us, there are other ways to solve it, but we impress on the court that what you're solving for is not an ideological concept. You're solving for a practical reality of how this provision is being interpreted in our magistrates' courts.
Exactly, Ms. Rajab-Budlender. How the problem is solved is not so much your problem, but it's the problem of this court.
I'm afraid that is correct, Justice Theron.
We have to interrogate.
Yes.
And when I hear your submissions about lack of certainty, inconsistency of application, then it seems to me the answer lies more in this court giving guidance. And I'm not saying that's the answer, I'm just raising it as a possible solution where even if we don't read in the word meaningful before consent, this court could say that if that consent must be interpreted to mean meaningful consent. And if that was the test of meaningful consent, even if we don't go as even if there may have been a subjective belief, if we interrogate meaningful consent, like in the Holstraker matter, there probably would have been a conviction. If we interpret consent to mean meaningful consent.
Justice Theron, the one issue I just wish to raise for the court to consider, should the court wish to go in that direction, is what I've mentioned before, which is that it's not just about consent, it's also about intention. So if one is simply to read in meaningful, it would not move us away from a position in which the subjective mindset of the perpetrator is what is evaluated. And that, in the context of these rape myths, and that's why I referred to the rape myths, makes it very difficult still to prove. So, for example, in a ridiculous example, extreme example, if a man genuinely believed, if he came from a remote area where he had no exposure to all of these laws, and he genuinely believed that if a woman smiled at him, it meant she wanted to have sex with him, then it would be impossible for a court to convict him of rape. And meaningful consent would have to encompass that.
Where a court has to interrogate subjective belief. It's got to be reasonable.
Sorry, Justice Theron, it has to be reasonable.
It's got to be reasonable. And if you interrogate that in the context of meaningful consent, it must be reasonable.
Yes, we say that the statute as it currently stands doesn't require that subjective consent to be reasonable. It's a different inquiry that has to happen. So if that is what the court thinks that the statute means, then we would ask the court to say that specifically. But as it currently stands, the subjectiveness of the intent, there's no reasonable element to the intention there at all in the statute.
If we were to read it as meaning meaningful consent, on the flip side of that would be that sexual penetration without meaningful consent would be prima facie unlawful.
Sorry, Justice, I'm going to ask you to say that again, please.
The flip side would mean that sexual penetration without meaningful consent of the complainant would be prima facie unlawful.
Yes. Yes.
Yes, thank you. Thank you, Ms. Rajab-Budlender.
Thank you, Justice.